In the last 2 days, Delhi Chief Minister Arvind Kejriwal almost got out of custody in the liquor policy case. Well, almost. There's a lot that happened on Thursday and Friday in his case, and in this video, I'll give you a roundup of all that happened in the trial court and in the Delhi High Court in his case. Now, what happened was late Thursday evening, Kejriwal was granted bail by vacation judge Nyay Bindu of the Rouse Avenue courts. And in this 25-page order, the court came down heavily on the Enforcement Directorate or the ED, observing that the ED had failed to give any direct evidence against the Chief Minister in respect of the proceeds of crime. Now, among other things, in this order, the judge took into consideration the Chief Justice of India's encouragement of trial court judges to grant bail during a speech on CBI Day's celebration. The court also relied on the Supreme Court's observations that Delhi Chief Minister Arvind Kejriwal is not a threat to society while granting him interim bail for campaigning for Lok Sabha elections in May this year. Now, in this case, Kejriwal's lawyers have also consistently pointed out the revision in Apoorva's statement saying that a few co-accused did not refer to Kejriwal initially but were then made approvers after they mentioned Kejriwal's involvement in the case and were accepted as prosecution witnesses. This is basically what an approver means. So now in its defense, ED had told the trial court that, and I quote, "Investigation is an art and sometimes one accused is given lollipop of bail and pardon and induced with some assurance to make them tell the story behind the offense," unquote. To this, the court said that it, and I quote again, has to take a pause to consider this argument, which is not a portable submission that investigation is an art, because if it is so, then any person can be implicated and kept behind the bars by artistically procuring the material against him after artistically avoiding or withdrawing exculpatory material from the record. The court said that this argument, and I quote again, constrains the court to draw an inference against the investigating agency or the ED in this case that it is not acting without bias, unquote. The court also, this is the trial court, it also noted that ED has been silent over the fact that Kejriwal was not named as an accused in either the CBI's FIR or the ECIR, which is the equivalent of an FIR registered by the ED, and that his name surfaced only later in the statements of the co-accused. Now, after this judgment was passed, of course, ED swiftly approached the Delhi High Court challenging the grant of bail to Kejriwal. The High Court halted Kejriwal's release on Friday morning and then heard the submissions by ED and Kejriwal's lawyers. Now, mind you, the submissions on Friday were only with regard to the stay application that the Enforcement Directorate has filed. So, it has essentially challenged the lower court's order in the High Court through an appeal and has also filed an application for stay of bail. So for now, the arguments were only on whether Kejriwal's bail can be stayed during the pendency of ED's appeal. Now, before the High Court, Additional Solicitor General S.V. Raju, appearing for ED, made a three-pronged submission among other things. He submitted that the trial court judge's order did not satisfy the twin considerations under Section 45 of the Prevention of Money Laundering Act 2002. Now, this provision says that bail can be granted to an accused in a money laundering case only if two conditions are satisfied. First, there should be a prima facie satisfaction that the accused has not committed the offense, and second, that he is not likely to commit any offense while out on bail. Now, ED also alleged that it was not given fair opportunity to present the prosecution side in the trial court, and that the trial court's order had taken irrelevant aspects into consideration to grant Kejriwal bail. Now, once again, in the High Court, ED's lawyers clarified that right now they were only arguing in the application for stay of bail. They also took exception to the bail order, which said that ED had failed to provide direct evidence against Kejriwal, highlighting the elements and statements of various witnesses against the Delhi CM. On the other hand, senior advocate Abhishek Manu Singhvi, arguing for Kejriwal, asserted that it was extremely unfortunate that the ASG had maligned the judge who granted Kejriwal bail. This whole approach, he said, is completely deplorable, and added that statutory objectivity has been lost as far as ED is concerned. Singhvi pointed out that before Judge Bindu, ED argued for over 3 hours. He then highlighted the difference between grant of bail and the cancellation or reversal of bail. He said that these are two completely different things, and that the threshold for cancellation of bail, which has been granted by a competent court, is higher, and asserted that the trial court did consider all aspects raised by ED in its order. Now, after hearing the arguments, Justice Sudhir Kumar Jain stayed the operation of the order granting bail to Kejriwal till it pronounces its order on the application for stay of bail. So, the court said, essentially the court has reserved its order on the stay application right now for 2 to 3 days and will pronounce an order on the stay application by early next week. But till then, the bail order will not be given effect to. The court also issued notice on the appeal filed by ED challenging grant of bail to Kejriwal in this entire case. We'll of course be keeping an eye at the High Court judgment and subsequent hearings, and will bring you the latest updates on all of this. That's it for now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.